The first knock didn't sound like a guest arriving late. It was measured, heavy, and repeated with the patience of someone who knew the door would open because the building belonged to the county if it needed to. I was standing at the front of the room with my jacket off, sleeves rolled once at the wrist the way I always do when I'm trying not to look like I'm trying. The officiant had just asked everyone to sit. Mara's hand was in mine, steady, her thumb resting on my knuckle like an anchor point. The second knock came through the music. The quartet didn't stop, but the notes wavered because the violinist looked toward the hallway. The venue manager appeared in the doorway behind the last row, face pale, lips moving without sound. He leaned toward my best man, Craig, and said something that made Craig's shoulders lift, then go rigid. Craig started walking toward me with a phone in his hand. He didn't hand it to me. He leaned close and said, "There are 2 deputies at the entrance. They're asking for you by full name." The word deputies is a cold word. It doesn't belong in wedding rooms. I looked at Mara. She didn't ask me anything. She just exhaled once through her nose and tightened her grip like she'd decided we'd deal with whatever it was in sequence. I nodded at the officiant as a signal to pause. He stopped talking without needing an explanation. I stepped down from the small platform and walked toward the hallway with Craig beside me. Behind us the room stayed mostly silent, the kind of silence that spreads when people understand something official has entered. At the end of the hall, just before the foyer, I saw them. 2 sheriff's deputies in tan uniforms, duty belts and radios. One had his hat off under his arm. The other kept his hand near his belt without touching anything. They weren't aggressive, they were careful. That was worse. The venue manager stood a few feet away like he wanted to disappear into a wall. The deputy without the hat said, "Are you Daniel Mercer?" I said yes. He looked at the card in his hand as if he didn't trust his own eyes. Then he said, "We need to speak with you outside the ceremony space." I said, "Is this about an emergency? Someone hurt?" He didn't answer that directly, which told me the answer wasn't simple. "It concerns an active report and an order," he said. "It's better we do this away from the guests." "An order from where?" I asked. "Probate division," he said. "Probate is a word that belongs to dead people in inheritance arguments. It's not a word that belongs near flower arrangements." I kept my voice level. "I'm getting married right now." The other deputy, younger, looked uncomfortable like he'd drawn the short straw. The older deputy's eyes stayed on mine. "I understand," he said. "This is time sensitive. We're not here to arrest you. We're here to serve you and to ensure compliance." "Compliance with what?" I asked. He held out a set of papers, stapled. The top page had a seal and the words EX Part Temporary Order in bold. The county seal sat in the corner like a stamp that ended conversations. I didn't take the papers right away. I looked at the seal, then the case number. I recognized the name on the caption line before I processed anything else. Elaine Mercer, respondent, Daniel Mercer. Elaine was my sister. The deputy said, "Sir, please take the documents." I took them. The paper was warm from his hand. The first paragraph stated that the court had received a petition alleging undue influence, coercion, and imminent dissipation of trust assets. It asserted that I had taken steps to access funds held in the Mercer Family Trust and intended to move them out of jurisdiction within the next 24 hours. It requested emergency relief, including a temporary freeze on distributions and a prohibition on me taking actions that could affect the trust, including entering into legal agreements that could create a claim against trust assets. My eyes found the section titled Order. It commanded that I not enter into any marital contract or legal union that could impact the administration and beneficiary rights of the trust until a hearing set for the next business day. It didn't say I couldn't marry, it said I couldn't create a marital claim against trust assets. The phrasing was deliberate enough to be used like a lever in the wrong hands. The deputy said, "The court also requested we confirm the status of the grantor." "The grantor?" I repeated. "Your grandmother, Evelyn Mercer," he said. My throat stayed dry. My grandmother wasn't dead. She lived in a memory care facility on the north side of town. She had good days, and days where she couldn't remember my name, but remembered the tune of an old hymn if you hummed it. Her signature had built half of what our family owned, and then she'd handed it to a trust with rules strict enough to outlive her confusion. I said, "She's in care. What status are you confirming?" The younger deputy finally spoke. "There's an allegation she's being kept from family, that she's being pressured to sign documents, and that you're planning to move money today." I heard the words, but what I felt was the timing. Today, during the ceremony, before the guests even ate. Elaine didn't just want to fight. She wanted to ruin the day and control the narrative in a single strike. I kept reading. Attached was a declaration signed by Elaine under penalty of perjury. It said she had evidence I obtained a durable power of attorney through coercion, and used it to instruct the trustee to expedite a distribution. It said I had isolated our grandmother. It said I had manipulated her because I had financial motive tied to marriage. There was a second attachment, an audio transcript excerpt. Not the audio itself, a typed excerpt, a few lines, allegedly, of me speaking to my grandmother about getting the paperwork done. It was carefully chosen. It could be read as sinister if you assumed the worst. It didn't include the context, which, if it existed at all, would matter. I looked up at the deputy. Who else has a copy of this right now? He didn't need to think. Your counsel, if you have one, and the trustee, and the bank. The order directs immediate notice. I asked, did you come here because the court asked you to stop the ceremony? He said, we're here to serve you and to ensure you understand the temporary restraints. The court did not order us to physically stop anything, but it did direct that you be notified immediately and that we verify the well-being of Ms. Mercer. I said, my grandmother is safe. I can give you her facility address and her doctor's number. She's not here. The older deputy nodded as if he'd expected that. We'll need to note that, also, sir, the petitioner requested a civil standby if there are volatile interactions. I almost laughed, but I didn't. Elaine always packaged her aggression as concern, then asked authorities to stand beside her while she lit the match. I said, is there a criminal report? The deputy hesitated, then said, a report of financial exploitation of an elder. It's being treated as informational at this moment, pending review. Who made it? I asked, though I already knew. Petitioner, he said, so she filed in probate and called law enforcement in the same breath. A two-pronged attack. One to freeze money, one to stain my name. I looked back toward the ceremony room. The door was closed now. The muffled silence inside felt like a held breath. I said, I'm going back in. I will comply with lawful orders, but this is based on false statements. I'll address it through counsel. The deputy said, we advise you not to contact the petitioner directly. I wasn't planning to, I said. He gave me a business card, case number for the report, a detective's name. I took it and placed it inside the stapled order, like I was filing it in my mind. Before I turned away, I said, did the court verify any of this before issuing an ex parte order? He answered carefully. Ex parte orders are issued based on sworn declarations in urgency. A hearing is scheduled. Elaine had sworn under penalty of perjury. That phrase always sounds powerful, until you remember how rarely it's enforced unless someone insists on enforcement with evidence. I walked back down the hall. Craig stayed beside me, quiet, reading my face the way he's always done since we were 12. When I opened the door, everyone's eyes turned at once. Mara stood near the platform, hands folded in front of her, expression composed. Her dress was simple, no lace, no drama. She looked like herself, which grounded me. I walked to her, then leaned close and said only what was necessary. My sister filed an emergency probate order. It's about my grandmother's trust. Deputies served me. Mara's eyes didn't widen. They narrowed slightly the way they do when she's calculating steps instead of reacting. What do they want? She asked softly. To freeze anything tied to the trust and to claim this marriage creates a claim, I said. It's procedural, but it's meant to disrupt. She nodded once. Are we allowed to continue? We're allowed, I said, but we need to be careful, and we need counsel now. She looked past me toward my mother sitting in the second row. My mother's face had gone tight, jaw set in that familiar way, that meant she was deciding whether to protect the family image or the family reality. Elaine had trained her to choose image. Mara said, then we handle it in order, we don't improvise. That was why I loved her. Not because she soothed me, but because she refused to let chaos set the sequence. I turned to the guests. I didn't explain details. I said, we have an unexpected legal issue that needs to be addressed immediately. We're going to take a short break. Thank you for staying seated. People don't like uncertainty, but they respect clarity. They stayed. The quartet didn't play. The silence became official. Mara and I stepped into the side room, the venue used for storage. Craig followed. My attorney, Martin Hale, wasn't invited to my wedding, but he was in my phone like a fire extinguisher. You hope never to use. I called him. He answered on the third ring, voice already alert, as if he'd been waiting. Daniel, he said. I just got a faxed copy of an order. Don't tell me you're seeing deputies. I am, I said. They served we at the venue. Elaine filed ex parte. Martin's exhale was controlled. She filed at 8:12 a.m., Judge Rivas signed at 9:03. The trustee was served at 9:20. The bank compliance office received notice at 9:28. It was 10:47 a.m. She timed it to land while we were standing in front of witnesses. Martin said, "Are you married yet?" "No," I said. "Good," he said, and I could hear him choosing words. "Not because marriage is wrong, because she's trying to create an argument that you're acting in haste to lock in a financial claim. We can neutralize that." Mara listened without interrupting, her eyes on me, not the phone. Martin continued. "Where are you physically?" "At the venue," I said. "Stay calm," he said. "Do not contact Elaine. Do not post anything. We're going to request an emergency hearing today if we can, or we'll file a motion to dissolve before tomorrow's hearing. But first I need to know what she alleged exactly, and what evidence she attached." "I have the papers," I said. "Read me the caption and the key allegations," he said. I did. When I got to the transcript excerpt, he stopped me. "Don't paraphrase. Read it." "Exactly," he said. I read the lines, they were short. "Chosen." Martin said, "That's not enough for an order, but ex parte judges sign based on fear of irreparable harm. We need to show there's no emergency and that her declaration is materially false." "What about the elder exploitation report?" I asked. "Separate lane," he said, "but connected. If she can trigger a criminal investigation, she can pressure the trustee to freeze distributions. The trustee is conservative, they'll freeze first, ask questions later." Mara asked, "Can we still get married today without complicating anything?" Martin paused. "Legally you can marry. The order can't stop that outright, but it can affect how the trustee treats requests. Also, Elaine's goal is optics. If you proceed, she'll claim you did it in defiance. Not illegal, but it feeds her narrative. The cleanest move is to postpone the ceremony until we get the order dissolved." Mara's face stayed neutral. She didn't flinch. But I saw her fingers press together once, a small sign of compression. I said, "We're not giving her the day." Martin said, "You're not giving her the trust. The day is a symbol, the trust is an asset. You can reschedule a symbol, you can't easily reschedule a distribution once it moves." I looked at Mara. She understood the distinction. Mara said, "We'll do it the right way, but we do not let her control the record." Martin said, "Exactly. Daniel, where is the original trust instrument copy? The one your grandmother signed in 2011 and amended in 2016. "In my safe, I so. And the trustee has originals." "I need the 2016 amendment," he said. "Specifically any clause about beneficiary changes and distribution triggers." "It's in there," I said. "Also," Martin said, "do you have the facility visitation logs for your grandmother? Any records showing you didn't isolate her?" "I have my visitor sign-ins because I always photograph them," I said. "Habit. Good habit," he said. "We'll use it." He lowered his voice slightly. "One more thing, Elaine's declaration claims you obtained a durable power of attorney, did you?" I said, "No." Mara's eyes shifted to me, a quick check. She knew this already, but hearing it said into a phone made it more real. Martin said, "Then we find out what document she's talking about, because either she forged your grandmother's signature or she's relying on an old document with conditions, if it exists at all." I said, "She wouldn't risk forgery." Martin didn't answer, he didn't need to. Elaine had always risked what she thought she could explain later. I ended the call with a plan. I would send Martin photos of every page. Mara would speak to the venue manager, and discreetly pause the ceremony without inviting speculation. Craig would keep guests occupied and quietly arrange transportation if people needed to leave. Before we stepped out, Mara said, "Your mother will call Elaine if you don't stop her." I said, "Then we stop her." I walked to my mother in the second row and knelt slightly, so my voice wouldn't carry. "Mom," I said, "do not call Elaine." Her eyes flashed. She called the police to my son's wedding. "She filed an order," I said. "If you call her, she'll record you and use it. We handle it through counsel." My mother's breathing went shallow. She didn't like being told what to do, but she liked being embarrassed even less. "Where is she?" she asked. "Doesn't matter," I said. "We're not feeding her." I stood and walked back to Mara. She had already spoken to the venue manager. He nodded, relieved to have direction. We returned to the front. The officiant looked at me as if asking permission to speak. I faced the guests again. "I appreciate your patience. We have a legal matter that requires immediate attention. We're going to postpone the ceremony today and reconvene as soon as possible. Please stay for food and time together if you can. We're not asking anyone to leave. We are asking for privacy while we handle something that can't wait. People murmured. Some looked angry on our behalf. Some looked curious. Curiosity is inevitable. But I could see respect in the way they didn't surge forward. Mara stepped beside me and added one sentence, calm and even. We want the day to be clean. We'll do it with full attention when it's time. That stopped the room from treating it like a melodrama. It made it procedural. Within minutes, my aunt started guiding people toward the reception space as if this had always been the plan. My father sat still, hands folded, staring at the floor like he was reading an invisible document. Craig moved like a coordinator, not a groomsman. He was good under pressure because he didn't try to be heroic. He just executed. Mara and went back into the side room. I laid the order on a folding table. I took photos of each page and emailed them to Martin. Then I called the trustee. The Mercer Family Trust had a corporate trustee, Pine Ridge Fiduciary Services. My grandmother chose them after my grandfather died because she didn't trust family to administer money without turning it into a weapon. She was right. The trustee's main contact on our file was a woman named Denise Kwan. She always spoke like she was in a room with microphones. I respected that. Her assistant answered, then transferred me. Denise picked up on the first ring. "Mr. Mercer," she said, "I was going to call you." "I'm sure," I said. "I've been served at my wedding." "I'm sorry," she said, and I believed she was sorry in the limited way professionals are sorry when a client's personal life collides with their inbox. "We received the temporary order. We have frozen all discretionary distributions pending the hearing." "I'm not requesting a distribution," I said. "The petition alleges you did," she said. "Then the petition is false," I said. "What request did you receive, and from whom?" There was a pause long enough that I knew she was choosing whether she could say it over the phone. "I can tell you," she said, "that we received a communication that appeared to be from an authorized agent of Ms. Evelyn Mercer. It requested an expedited distribution to a newly established account." "Authorized by what?" I asked. "A power of attorney." "Yes," she said more cautiously. "I need a copy," I said. "Due to the order," she said, "we have to be careful about disclosure. That you are a beneficiary and you are named as a successor trust advisor under the 2016 amendment, subject to conditions. I can provide you with copies through counsel." "I have counsel," I said. "Martin Hale. Send everything to him." "Already noted," she said. "Mr. Hale called. We will comply." I said, "Denise, I'm asking you as a fiduciary. Did you verify the power of attorney before acting on it?" "We initiated verification," she said. "We requested the notarization details and facility confirmation. Before completion, we were served with the ex parte order. That halted our process. So Elaine hadn't gotten the money. She'd gotten the freeze. That was her real objective." I said, "What's the account information for the requested distribution?" "I can't give that verbally," she said, "but it was not an account previously associated with you." That detail landed like a pin in a map. "Not my account," meaning Elaine wasn't just trying to stop me. She was trying to route money to herself under cover of accusing me. I said, "Then the fraud is hers." Denise didn't respond to that. She couldn't. She said, "Mr. Mercer, I advise you to focus on dissolving the order. The hearing is set for 9 a.m. tomorrow." "I'm not waiting," I said. "She used my wedding day. We'll use today." After I hung up, Mara looked at me. "She tried to move money today." "Yes," I said. "Not to me." Mara's voice stayed even. "Then the record already exists. The trustee has her communication." "That's the only reason I'm not panicking," I said. "She can accuse all she wants. The trustee's logs don't have emotions, they have timestamps." Mara nodded once. "What's next?" I looked at the detective's name on the deputy's card, Detective Raul Soria. I didn't know him, but I knew how these reports worked. The first narrative that reaches the system becomes the default until another narrative arrives with documents. So I called the number. A receptionist answered, then transferred me. It rang 4 times. A man picked up. "Soria," he said. "Detective Soria," I said. "My name is Daniel Mercer. I was just served with a probate ex parte order at my wedding. I understand there's an elder exploitation report filed against me. I'm calling to provide information and to request that your investigation include the underlying records." There was a pause. He didn't sound surprised. "You're the respondent," he said. "Yes," I said. "Are you calling me from the venue?" he asked. "Yes," I said. "Okay," he said. "First, I appreciate you calling directly. Second, do not discuss substantive details over an unsecured line. Third, I need to ask, where is Evelyn Mercer right now?" "At Northwood Memory Care," I said. "Room 214. Her attending physician is Dr. Patel. The facility can confirm she's safe. I can also provide visitation logs. He listened. Who has legal authority over her care decisions? There's a healthcare proxy, I said. Not me, it's split. Elaine is listed as alternate. Primary is my mother. Financial authority is through the trust and through a guardianship plan that was never activated. So you don't have POA, he said. No, I said. And I need to know what POA was submitted. He didn't answer that. Instead, he said, we've had cases where family members accuse each other to get ahead of a distribution. We're going to look at documents. I want you to, I said, because the petition alleges I requested an expedited distribution. I did not. The trustee received a request, but I believe it was directed to an account not associated with me. That was the first moment his tone shifted. How do you know that? From the trustee, I said. They didn't give details, but they stated the requested account wasn't previously associated with me. He said, who had the trustee told you? Denise Kwan, I said. Pine Ridge Fiduciary. Okay, he said. Here's what we'll do. I'll open a formal case file for the report instead of leaving it informational. That doesn't mean you're a suspect. It means I can issue requests and hold records. I'm going to contact the trustee for the submitted documents. I also want you to email me any relevant records you have, including visitation logs, any communications with your grandmother, and any documentation about the trust. I can do that, I said. Also, he said, I want you not to contact Elaine. If she reaches out, don't respond. Save everything. I'm not speaking to her, I said. He gave me an email address with the county domain. I repeated it back, he confirmed. Then he said, one more thing, the deputy said you were calm. Keep it that way, the fastest way through this is paper. When I hung up, Mara said, he's not on her side, he's on procedure, I said. That's good enough. We sat for 30 seconds in the side room, not speaking. Outside I could hear plates moving, the low murmur of people trying to decide whether this was tragedy or inconvenience. Then my phone buzzed, a message from an unknown number, but I recognized the first line. I'm sorry it had to happen like this, Elaine. The second line followed. If you do the right thing, I'll withdraw it before tomorrow. That was the offer. Comply with whatever she wanted, or she'd keep the knife in. Mara looked at me. Don't answer. I'm not, I said. I screenshot the message and emailed it to Martin and to Detective Soria. Within 5 minutes, Martin called back. Elaine just texted you, didn't she? He said. Yes, I said. Good, he said. Because that shows she's using the order as leverage. Keep everything. He sounded focused, not angry. I'm filing an emergency motion to dissolve today. Judge Rivas may not hear it, but we can request a same-day hearing with the duty judge. Also, I'm sending a letter to Pine Ridge demanding preservation of all communications, including metadata. If Elaine forged anything, we'll need the original submission files. Mara asked, can we go to the courthouse today? Martin heard her voice. He paused, then said, if you're willing, it will be sterile and unpleasant, but yes. Sometimes showing up with a calm face and a stack of documents is the difference between a judge treating it as a family squabble versus treating it as abusive process. I said, we're coming. Martin told me where to meet him. The probate clerk's office by 1 p.m. He asked me to bring any physical trust documents I could. I said I had them in a safe at home. Get them, he said, and do not go alone. Craig drove us. He didn't ask questions until we were in the car and the venue was behind us. Then he said, tell me what matters. I told him in sentences. My sister filed an ex parte order. She claimed I exploited Grandma. She froze distributions and tried to block marriage. There was an elder exploitation report. Craig's hands tightened on the wheel. Elaine picked the day on purpose. Yes, I said. Mara looked out the window. She's not trying to win an argument, she said. She's trying to create a record that makes everyone else hesitate. That's exactly it. I said. At home, I opened my safe. Inside were the copies my grandmother had insisted I keep. The original trust summary letter, the 2016 amendment, and her handwritten note to me that had never been legally relevant but had always been personally relevant. I left the note. I took only what could stand in court. There was a clause in the 2016 amendment that I knew by memory because I'd read it the day it was signed. It stated that if any beneficiary initiated litigation in bad faith to alter distributions or to coerce other beneficiaries, that beneficiary could be deemed in breach of the trust's no contest provision and have their share reduced or held in discretionary trust. My grandmother had written that after Elaine sued my father in small claims court over a car title, and then tried to claim she was standing up for herself. My grandmother had watched Elaine weaponize systems. She'd built a countermeasure into the trust. It wasn't automatic, it required a finding, but it existed. I took the amendment and placed it in a folder. Then I went to my desk and pulled up my email archive. I searched Northwood and found the facility confirmation emails, appointment reminders, care plan updates, a message from the social worker confirming that Elaine had visited only twice in the last year. I printed them, not because I loved paper, but because judges respect a stack you can hold. By noon we were in Martin's office. Mara and Craig sat in chairs while Martin stood at the copier, scanning pages with the speed of someone who'd learned long ago that delay is its own enemy. He looked at the trust amendment and tapped the no contest clause with a pen. "She's playing with fire," he said. "If we can show bad faith, the trustee will have grounds to restrict her." Mara said, "Can we prove she's the one who submitted the distribution request?" Martin nodded slightly. "That's what I'm going to find out. The trustee will have an email header, a fax line record, a portal login, something. People think document means paper. It usually means metadata." He assembled the emergency motion. It argued that the ex parte order was based on materially false statements, that there was no imminent harm because no distributions had been requested by me, and that the order was being used to interfere with a personal event to create leverage. It attached the trust amendment showing my limited role, the facility logs, and my declaration denying any POA. At 12:40 p.m. we walked into the courthouse. Courthouses have a specific smell, old paper, disinfectant, and the breath of people who thought they'd never be there. We passed through security. The guard looked at Mara's ringless hand and the faint crease where a ring would soon sit. He didn't ask, he'd seen everything. The probate clerk's office was crowded. Martin moved with a practiced patience, stepping into line, checking the wall clock, then turning to me. "Remember," he said quietly, "this isn't about convincing anyone you're good, it's about showing her filing is defective." Elaine had turned it into an urgency contest. We had to win on procedure. We filed the motion. The clerk stamped it with the date and time. That stamp mattered. It turned our story into part of the official sequence. Martin requested an emergency hearing. The clerk said the duty judge might review at 3 p.m. depending on the docket. We sat on a bench in a hallway with vending machines. Mara rested her head lightly against my shoulder, but she didn't hold on like she needed support. It was more like she was marking time. At 2:07 p.m., Martin's phone rang. He stepped away, listened, then came back. "Judge Klein will hear it at 4:15, he said. "Courtroom 4B. Elaine has been notified." Mara's eyes stayed on his face. "Will she show, Martin said. "This is her stage." We had 2 hours. Martin used them to call Denise at Pine Ridge. He put the call on speaker with my permission. Denise's voice came through crisp. "Mr. Hale, Ms. Quan," Martin said, "I'm requesting immediate preservation and production of the communication that requested an expedited distribution today, including the power of attorney presented, and any account information." Denise said, "We have placed a litigation hold. I can provide you with copies by secure portal within the hour." Martin said, "Do you have any preliminary verification results?" Denise hesitated. "We contacted Northwood Memory Care to confirm whether Evelyn Mercer executed any power of attorney recently. The facility stated they have no record of such execution on site. We also checked our file. There is an older financial power of attorney from 2009, naming your client's father, now deceased, and then naming Elaine Mercer as alternate. However, it appears to have been superseded by the trust structure and was not used in prior interactions." Mara's gaze flicked to me. "Elaine had an old document with her name on it. That was her foothold." Martin said, "What about notarization?" Denise said, "The submitted power of attorney attached to the distribution request included a notary seal. We have not verified it yet. The notary name is Karen Lutz, commission number included." Martin's voice tightened slightly, not with anger but with precision. "We will be subpoenaing that notary's journal if needed." Denise said, "Understood." After the call, Martin looked at me. "This is the pivot. She alleged you used POA. She actually used an old POA naming herself, or she forged a new one. Either way, she's the one trying to move money." Mara said, "Then why accuse Daniel? Because if she's the petitioner, she looks like the protector," Martin said. "If Daniel is the respondent, he looks like the predator. The court acts faster when it thinks it's stopping a predator." At 3:12 p.m., Denise sent the portal link. Martin opened it on his laptop. He didn't speak right away. He just scrolled. Then he turned the screen toward me. The distribution request was a PDF attached to an email sent through a generic Gmail address. The name displayed was E. Mercer Care Coordinator. The body of the email was written in formal language, referencing the trust and requesting a one-time emergency distribution for medical expenses and care transition costs. It included a routing and account number for a new bank account in a different county. The attachment included a power of attorney document dated 2 weeks prior, allegedly signed by my grandmother, naming Elaine Mercer as attorney-in-fact. It included a notary acknowledgement. The signature on the POA looked like my grandmother's name, written by someone who'd seen it once and tried to imitate it. My grandmother's real signature had a slow loop on the E and a sharp finish on the R. This one was smooth and fast like a practiced fake. Mara leaned in, eyes scanning. "That's not her signature," she said quietly. Martin pointed to the notary block. "Karen Lutz," he said. "Commission expires next year. We can check the state database, but more important is the journal. Notaries keep logs." I stared at the email header. It showed the sending IP address and timestamp. The email was sent at 7:46 a.m. today, before the petition was filed. Elaine tried to move money, then filed the petition to accuse me, then called law enforcement. She built a smokescreen after attempting the theft. Mara sat back. "She tried to steal the trust fund," she said, but her tone wasn't shocked. It was confirmed. Martin said, "We walk into court with this. We don't call it stealing. We call it attempted unauthorized distribution based on unverified authority. We let the judge supply the moral language in his own mind." At 4 p.m., we walked to courtroom 4B. Elaine was already there. She sat in the front row, legs crossed, hands folded over a cream-colored folder like she was a witness in a documentary. She wore a navy dress appropriate for court and inappropriate for empathy. Her hair was pulled back. Her face looked calm, but her eyes moved constantly, tracking Martin, tracking me, tracking Mara. She wasn't alone. My mother sat beside her. That was the second betrayal of the day, quieter but sharper. My mother had ignored my request not to contact Elaine. She'd chosen proximity over principle. Mara's posture didn't change, but her gaze moved to my mother and held for a moment. It wasn't anger, it was accounting. Elaine stood when she saw me, as if she were greeting someone at a funeral. She didn't come close. She didn't need to. She wanted the room to see her restraint. "Daniel," she said softly. I didn't respond. I sat in the second row behind Martin. Mara sat beside me. Craig sat behind us like a wall. Elaine looked at Mara. "I'm sorry for the disruption," she said, still soft. "I didn't want it to be public, but I didn't have a choice." Mara didn't answer. Elaine looked wounded for half a second, then recovered. She sat back down and placed her folder on her lap, fingers resting on it, as if it were evidence of her virtue. At 4:15, the bailiff called the case. The duty judge, Judge Klein, entered. He was older, gray hair, glasses low on his nose. He sat, looked down at the file, then looked up. "This is a motion to dissolve an ex parte temporary order issued this morning," he said. "I have reviewed the pleadings. Counsel, appearances." Martin stood. Martin Hale for respondent Daniel Mercer present. Elaine stood without counsel. That was intentional. If she appeared pro se, she looked like a concerned family member, not a litigant with strategy. "I'm Elaine Mercer," she said. "Petitioner." Judge Klein looked at her. "Ms. Mercer, you filed an ex parte petition alleging imminent dissipation of trust assets and coercion of an elder. You understand that statements under oath are subject to penalty." "Yes, Your Honor," she said, voice steady. "That's why I filed. Because it's serious." Judge Klein nodded once, then looked at Martin. "Mr. Hale." Martin didn't overspeak. "Your Honor, the ex parte order was obtained based on materially false claims. My client has not requested any distribution. He has no power of attorney. He has not isolated the grantor, Evelyn Mercer. The petitioner, however, appears to have submitted a request to the trustee this morning, using a purported power of attorney, naming herself, with a signature that is suspect. We have trustee records. We are asking the court to dissolve the order and to set this matter for an evidentiary hearing with appropriate safeguards." Judge Klein's eyebrows moved slightly. "You're alleging the petitioner is the one who initiated the distribution request." "We have the communication," Martin said, "with timestamps." Elaine's face didn't change, but her hands tightened on the folder. I noticed because she always squeezed when she lied, a small habit from childhood when she'd deny breaking something while crushing the evidence of her own tension. Judge Klein looked at Elaine. "Ms. Mercer, did you request a distribution from the trust today?" Elaine lifted her chin. I requested that the trustee be aware of urgent expenses for my grandmother's care. Daniel has been handling everything without transparency. I was trying to protect her. Judge Klein looked back at Martin. Do you have the document? Martin handed it to the bailiff, who brought it to the judge. The judge looked at the email, then the attachment. He didn't comment on the signature. He focused on the structural facts. Sender address, time, request, authority claimed. Judge Klein looked up. Ms. Mercer, this email appears to be a direct request for funds to be moved to an account. Is this your email? Elaine's eyes moved once to my mother, then back. I have multiple emails, she said. I used one for coordinating care. Judge Klein's voice stayed flat. Is that your email? Elaine paused a fraction too long. Yes, Your Honor. The air changed, not emotionally. Procedurally. She had just admitted ownership of the channel used to request money. Judge Klein asked. The petition you filed this morning alleges the respondent requested an expedited distribution. Why did you allege that if you were the one communicating with the trustee? Elaine's voice remained controlled. Because Daniel has been acting as if he's entitled. He has been speaking to the trustee, to the facility, to everyone, and I have been shut out. When I contacted the trustee, they told me there were instructions in motion. I believe Daniel was behind it. Judge Klein looked at Martin. Is your client a trust advisor? Martin said, he is named as a successor trust advisor under conditions. Those conditions have not been triggered. The trustee has treated him as an information recipient only. Judge Klein nodded, eyes returning to Elaine. Ms. Mercer, the power of attorney attached here is dated 2 weeks ago. Where did it get executed? At the facility, Elaine said quickly. Judge Klein's gaze sharpened. Do you have the facility's acknowledgement? Witness statements, notary journal. Elaine opened her folder and produced a photocopy of a facility witness statement, a single page with a printed name, and a signature that looked like it had been written without pressure, like a practiced autograph. Martin rose. Your Honor, we have emails from the facility stating they have no record of such execution. Additionally, the trustee contacted the facility, and the facility denied any record. We have that information through the trustee. Judge Klein held up a hand. One at a time, he looked at Elaine. Who is the notary? Elaine answered, Karen Lutz. Judge Klein said, Notaries keep journals. Do you have a copy of the relevant entry? Elaine said, Not yet. Judge Klein leaned back slightly. Then at this moment I have an ex parte order restricting the respondent based on an allegation that he intended to dissipate assets. Yet the record before me shows the petitioner requested a distribution using authority claimed under a power of attorney that has not been verified, into an account not previously associated with the respondent. Ms. Mercer, do you understand the problem? Elaine's face stayed composed, but I saw a faint color shift in her cheeks. I was trying to protect my grandmother, she said again. Judge Klein's voice didn't rise. Protecting an elder does not include moving trust funds to a new bank account under a contested authority instrument. That is precisely what courts intervene to prevent. Elaine's controlled persona held for another second. Then she said, Daniel is marrying her today. He's been planning to get access. Stop, Judge Klein said. Not loud, just final. This court is not going to entertain insinuations about marriage in place of evidence. The issue is whether there was an emergency justifying ex parte relief, and whether the order is being used appropriately. He looked at Martin. Mr. Hale, what relief are you requesting right now? Martin said, Dissolution of the temporary order, Your Honor, and an order compelling the petitioner to produce the original power of attorney and any communications with the trustee, and an order directing the trustee to preserve all records. Additionally, given the apparent misuse of process, we request that the court refer the matter for review of potential perjury and fraud. The word fraud landed without drama. It didn't need drama. Judge Klein looked at Elaine. Ms. Mercer, do you have the original power of attorney? Elaine swallowed. It's at home. Judge Klein said, Where is home? She gave an address. It was her condo. Judge Klein looked at her. This court expects you to understand that when you allege undue influence and financial exploitation, you are asking the government to act quickly and harshly. If you lie, the government will act quickly and harshly on you. Elaine's voice became smaller. I didn't lie. Judge Klein turned to Martin. I'm dissolving the portion of the order restricting marriage-related actions. That is beyond the proper scope of this emergency petition. I'm also dissolving the restrictions on the respondent absent further evidence. However, Given that there is a dispute and an allegation involving an elder, I am ordering the trustee to maintain a temporary hold on any discretionary distributions for 72 hours pending a full evidentiary hearing. That protects the trust without punishing the wrong party. Martin nodded. That was a win and a containment. It removed the stain from my actions while protecting the asset until the facts were fully visible. Judge Klein continued. Ms. Mercer, you are ordered to produce the original power of attorney within 24 hours to the court and to opposing counsel. You are also ordered to provide the court with documentation of the notary journal entry. If you cannot, you will explain why under oath. Elaine's jaw tightened. Your Honor, Daniel has been nem mine mon Ms. Mercer, Judge Klein said. If you interrupt again, I will hold you in contempt. This is not a family meeting. Elaine went still. Judge Klein looked at Martin again. Mr. Hale, I will set an evidentiary hearing within 7 days. I also want the facility administrator present, or by declaration, and I want the trustee's records custodian. He glanced down at the file. Finally, I am directing that a copy of today's proceedings be forwarded to the county attorney for review. This court will not be used as a tool for financial games. He struck the gavel once. Not for drama, for closure. Outside the courtroom, Elaine approached my mother immediately. My mother stood and started speaking fast, face pinched, hands moving. Elaine nodded slowly, playing the steady one, letting my mother do the frantic work. Martin stepped close to me. We got what we needed, he said. We stripped the ex parte leverage and forced her to produce originals. Mara asked, as she forged it, will she destroy it now? Martin's eyes stayed calm. If she destroys it, that's obstruction, and we already have the copy the trustee received with metadata. Plus the notary either exists and has a journal entry, or she doesn't. Forgers always forget the third-party record. We walked out of the courthouse into late afternoon light. My phone buzzed with messages from guests, from people who had left the venue quietly, from my aunt saying she boxed up the cake and told the caterer to store it. One message came from my father. It was short. I didn't know, I'm sorry. I didn't respond yet. Not because I didn't care, but because I was still measuring who was part of the problem by choice, and who was part of it by weakness. At 6:10 p.m. Detective Soria called. Mr. Mercer, he said, I received your email, thank you for the documents. I also contacted Pine Ridge. They're cooperating. I'm requesting the original instrument used to claim authority. I need you to know something. We pulled the notary's commission record. Karen Lutz is a valid notary. Her office is in the same building as Elaine's condo complex. That was a detail Elaine hadn't anticipated would matter. Not illegal on its own, but it created proximity, and proximity creates questions. Soria continued, I called Ms. Lutz. She confirmed she notarized a document for Elaine Mercer 2 weeks ago. She says Evelyn Mercer was present and signed. I didn't speak for a second. Mara listened, face still. Soria said, before you react, understand that notaries can be deceived too, or they can be complicit. We're going to obtain her journal entry and any ID copies. Under our statute, if an elder is involved, the standards are tighter. I said, my grandmother doesn't leave Northwood, she hasn't been off campus in months. Soria said, then that's what we're going to verify. I'm sending a unit to Northwood to confirm her whereabouts during the notarization date, and to pull their sign-out logs and any camera footage. We're also going to check if any transport service was used. Mara asked quietly, can you ask if the notary took a thumbprint? Soria paused. Good question. In this state, thumbprints are required for certain documents. Power of attorney often falls under recommended practice. We'll see what she did. After the call, Mara said, Elaine didn't need to bring Grandma anywhere. I looked at her. Mara said, if the notary is complicit, she notarized without Grandma present. It was the simplest explanation. Elaine had always been good at finding someone willing to bend a rule for a fee. At 7:30 p.m., Martin sent me the filed order dissolving the ex parte restrictions. The PDF had the judge's signature. That signature mattered as much as any emotion did. It restored my legal footing. Mara and I ate dinner at home from a takeout container someone had dropped off. The house was quiet. The suit bag still hung on the back of a chair. Her dress was in a garment bag upstairs, untouched, as if waiting for the day to resume. We didn't talk much, we didn't need to. Our language that night was email forwarding, document naming and keeping our phones charged. At 9:05 p.m., another message from Elaine arrived, from the same number. You're making it worse, stop involving police. This is family. I didn't answer. I screenshotted again and sent it to Soria and Martin. Mara looked at me. She thinks the system belongs to her when it helps and to family when it doesn't. Yes, I said. And she'll keep shifting until the record pins her. The next morning, before 8 a.m., Detective Soria emailed me an update. It was brief, just enough to tell me the direction. Northwood confirmed Evelyn Mercer did not leave facility on date in question. Facility has video coverage of exits. Reviewing. Notary journal requested. Subpoena in progress. Also, bank account and distribution request opened last week. Account holder name matches petitioner. That last line was the first truly decisive piece. Elaine hadn't just requested money for care, she'd requested money into her own account. The moral claim collapsed under the administrative fact. At 10:12 a.m., Martin called. We have the account details now through the trustees' compliance team, he said. It's Elaine's account, sole owner. Mara sat across from me at the kitchen table, a laptop open with a spreadsheet of timestamps she'd started building without me asking. She looked up as I spoke. Her expression didn't change. It didn't need to. Martin continued, Judge Klein's order forced her to produce the original POA by this afternoon. If she produces it, we examine it. If she doesn't, we move for sanctions, and the no contest clause becomes relevant. I said, my mother is with her. Martin's tone stayed neutral. Your mother may become a witness whether she wants to or not. At 2:40 p.m., Elaine filed a notice through the clerk. She could not locate the original power of attorney. She requested additional time. She attached a statement from notary Karen Lutz, saying she had notarized a POA with Evelyn Mercer present. Elaine's strategy was shifting from producing evidence to producing excuses. Martin didn't wait. He filed a motion for expedited discovery and sanctions, attaching the facility statement that Evelyn never left and the bank record showing Elaine opened the account. By 5 p.m., Judge Klein issued another order. The notary was to appear in court within 48 hours with her journal. The facility administrator was ordered to provide exit footage and sign-out logs for the notarization date. This is what authority looks like when it turns. Not shouting, orders with deadlines. 2 days later, in a smaller hearing room, the notary appeared. Karen Lutz was in her late 50s, wearing a cardigan and a tight smile. She carried a bound journal like it was a shield. Elaine sat behind her, not beside her, as if distance could create innocence. Detective Soria was present in plain clothes, seated near the wall. His presence changed the air. This was no longer just probate, it was potentially criminal. Judge Klein asked the notary to swear in. She did. He asked her to open her journal to the entry for the date in question. She flipped pages, her fingers slightly stiff. Martin requested to see the ID record. The notary hesitated, then turned the journal toward the court. There was an entry. It listed a signer, Evelyn Mercer. It listed an ID type, driver's license. It listed an ID number. My grandmother didn't have a current driver's license. It had expired years ago. The facility kept her documents locked because residents sometimes wandered and lost things. Judge Klein asked, Did you personally inspect the signer's identification? Karen Moot said, Yes. Judge Klein said, Describe the signer. Lutz said, An older woman, white hair, slightly confused but able to sign. Soria spoke for the first time with the judge's permission. Your Honor, Northwood facility records show Ms. Evelyn Mercer was present in the facility during the entire day in question. Their exit cameras show no departure. Their sign-out logs show no family pickup. Additionally, her state-issued ID was secured in their records office. She did not have access to a driver's license. The notary's tight smile slipped. Elaine's face remained composed, but her eyes moved rapidly, calculating exits. Judge Klein asked the notary, Is it possible you notarized this document without the signer present? Lutz said, No, Your Honor. Judge Klein looked at her. Then the only remaining possibility is that the facility records are false, or your journal entry is false, or the person you notarized was not Evelyn Mercer. The notary's breathing became visible. Martin asked permission to introduce another record. A still image from the condo building's lobby camera, obtained through subpoena, showing Elaine entering the building with a woman in a wheelchair on the date in question. When Martin displayed it, the room didn't react like a TV show. No gasps. Just a collective stillness. The woman in the wheelchair was not my grandmother. Different face, different posture, younger by at least 10 years, but she wore a scarf similar to one my grandmother owned. Elaine had staged a stand-in. Judge Klein stared at the image. Then he looked at Elaine. Ms. Mercer, he said, stand. Elaine stood, smooth, as if she'd practiced. Judge Klein said, This court is referring this matter to the district attorney for investigation of fraud, perjury, and potential elder exploitation. Additionally, the temporary hold on distributions will remain until the trustee completes a full review, and I am issuing an order that you have no authority to act on behalf of Evelyn Mercer in any capacity pending that review. Elaine said, Your Honor, this is... Stop, Judge Klein said again, the same quiet finality. You have spoken enough. He looked at the trustee representative present by video. Ms. Kwan, the trustee will consider whether the no contest clause is triggered. This court is not determining beneficiary forfeiture today, but it is noting for the record that this petition appears to have been filed in bad faith and with an attempted diversion of trust funds. Denise Kwan's voice came through the speaker. Understood, Your Honor, we will proceed accordingly. That was the institutional decision, not a dramatic sentence. A professional acknowledgement that Elaine's access would be restricted and her share could be restructured or delayed. After the hearing, Detective Soria approached me in the hallway. Mr. Mercer, he said, we're taking statements. Your sister may be arrested depending on the DA's decision. The notary will also be investigated. I want you to understand that this won't resolve in a day, but the immediate risk to the trust is contained. Contained. That word mattered. It meant the system had placed the asset behind glass. Mara stood beside me, hands folded. She didn't smile. She didn't need to. Her calm was the only appropriate response to a record finally aligning with reality. That weekend, the trustee sent formal notice. Distributions remained paused, pending review, but beneficiary access protocols were updated. Elaine was restricted from contact with the trustee, except through counsel. Any attempted requests would be rejected automatically and reported. My mother called me once, late at night. Her voice was unsteady. Daniel, she said, I didn't know she would do that. I didn't accuse her. I didn't comfort her. I said, you sat beside her while she did it. Silence, she said. She said you were taking everything. I answered with the only thing that mattered. The account was in her name. My mother's breath caught. I saw the judge. I saw the picture. I don't understand. You don't need to understand, I said. You need to accept what the records show. A week later, Mara and I got married on a Tuesday afternoon in a small civil ceremony, just us, Craig, and a clerk who had seen worse interruptions than ours. We didn't invite my family, not as punishment, as containment. The clerk asked if there were any legal impediments. We said no, because there weren't any more. The ex parte order was dissolved. The court had clarified the scope. The trustee had frozen the right things for the right reasons. The only remaining process was accountability, and that would unfold without us standing in its way. After the ceremony, Mara and I sat in our car outside the building. She placed her hand on mine, no speech, just pressure. I said, Elaine tried to use police to stop it. Mara said, and police became part of stopping her. That was the moral shape of it, not vengeance, alignment. Months later, the district attorney charged Elaine with attempted theft by deception and filing a false instrument. The notary faced separate charges for improper notarization and falsifying journal entries. The trust remained intact. The trustee petitioned the court to place Elaine's share into a discretionary subsist with strict oversight, citing the no contest clause and her demonstrated misuse of process. The court agreed. Elaine didn't lose everything. The system rarely gives you the clean satisfaction of total loss. But she lost control, she lost speed, she lost the ability to weaponize urgency. That was the justice. The kind that lives in restrictions and logs, not speeches. Sometimes people ask me if I hate her. That question always feels like a trap. Hate would imply she still has access to my internal life. She doesn't. What she has is a case file with her name on it, a set of stamped orders, and a trustee's permanent note that flags her communications for compliance review. She built that for herself. The day she chose to interrupt, she thought she could turn authority into a costume. She assumed uniforms and seals would point in the direction she pointed them. What she didn't account for was that documents have weight, and weight accumulates. A text message, an email header, a bank account opening date, a facility sign-out log, a camera still, a notary journal entry with an ID number that didn't belong to my grandmother. When those pieces stack in the right order, the story stops being personal. It becomes administrative. And administration doesn't care who cries first. Mara and I keep a folder now. Not because we live in fear, but because we respect how things are proven. The folder contains court orders, trustee letters, and the timeline Mara built. It's not a souvenir. It's a reminder that calm is only useful when it's paired with records. If you've had someone try to rewrite your reality through institutions, you already know the temptation is to respond with emotion. Emotion is easy to dismiss. Paper is harder. If you want, tell me in the comments what system you've had to learn faster than you wanted to, and how you kept your footing inside it. And if you're here for stories where power flips because facts hold, you can subscribe. I'll keep it precise.